If people could take your seats, please. Go ahead. Oh, we're starting our clock, so I'm being prompted to start now. As a reminder, for people joining remotely, there will be a CLE code in the chat and Q&A boxes, so you need to join the chat to see the CLE code. Please write it down. If you've dialed in for this particular session, just a reminder also that each session has its own link, so you need to relink in for each separate section. This will be our last morning session, followed by lunch, and materials are on the app or on the conference website. Questions can be asked through the chat for virtual people, and if there's time, we'll have live questions here on the side as well. So we have our first in-person person in the room, Judge Gropper, and thank you for coming in person. We also have the rest of the panel remotely that will be on the screen. I will introduce the panel itself, which is the limits on collective action through global proceedings, recognition and enforcement issues, and complex multi-jurisdictional restructurings. We have esteemed panelists from around the globe talking about these issues with the panel moderator of the Honorable Mr. Justice Zacaroli, who is the UK High Court Judge in the Chancery Division. Mr. Justice Zacaroli was born in Sutton Codfield and educated locally at Bishop Wallace Comprehensive School. He studied law at Pembroke College in Oxford, where he recently was elected as an honorary fellow of Pembroke College. Mr. Justice Zacaroli was called to the bar in 1987 and became a Queen's Counsel in 2006. He specialized for most of his career in insolvency, banking, and commercial law, and he's been a member of the Management Committee of the Bar Pro Bono Unit since 2001, the Insolvency Rules Committee since 2012, and the Financial Markets Law Committee since 2015. He was appointed a High Court Judge, Chancery Division in November of 2017. With that, I'll turn the panel over to Mr. Justice Zacaroli.
Thank you, Lisa, and good morning, everyone. Let me just briefly introduce my fellow panelists. First of all, Professor Andre Borraine. Andre has been at the University of Pretoria since 1985 and as a full professor since 1999 and Dean of the Law Faculty since 2011. He's an acknowledged world expert in insolvency law and preeminent across the Southern African development community. We're very grateful that he's joining us today. Next is Pamela Huff. She is the National Group Practice Leader of the Restructuring and Insolvency Group of Blake, Cassels and Graydon LLP in Toronto. She also is highly experienced in the field, having represented debtors, creditors, trustees, and many others for 30 years before all levels of court across Canada. And finally, I'm afraid looking rather lonely, for which we're very sorry, Allan, former US Bankruptcy Court Judge Allan Gropper. He is, I think, in this gathering, the epitome of the man that needs no introduction. After 15 years on the bench, Allan carries on his work in the insolvency field as arbitrator, mediator, and expert witness. So that's the panel. Now, we're going to start by asking each of the panelists to tell us something about the routes to recognition of foreign insolvency proceedings, restructuring proceedings, and possible challenges faced in each of their jurisdictions. So without more ado, I'll hand over, if I may, to Pamela.
Oh, thank you very much for the introduction. I'm going to set the table for this panel discussion by giving a brief overview of the adoption of the UNCITRAL model law and cross-border insolvency in Part 4 of the Companies Creditors Arrangement Act, the CCAA, which is the Canadian statute for the restructuring of commercial entities. So the overview of the CCAA structure provides for the recognition of foreign main and non-main proceedings as contemplated by the UNCITRAL model law. So first, the CCAA defines a foreign proceeding as a judicial or an administrative proceeding, including an interim proceeding in a jurisdiction outside Canada, dealing with creditors' collective interests generally, under any law relating to bankruptcy or insolvency, in which a debtor company's business and financial affairs are subject to control or supervision by a foreign court for the purposes of reorganization. So US Bankruptcy Code Chapter 11 proceedings are routinely recognized under the CCAA. Many of the people in the room, I wish I was there in person to join you, but many of the people in the room will have participated in that in various roles. Similarly, Canadian CCAA restructuring proceedings are routinely recognized in the US. Very recently, UK schemes of arrangement have been recognized as a foreign proceeding in Canada. That was the Ccaa restructuring, a global logistics entity. There was a Netherlands company and a UK company that proposed a scheme of arrangement in the UK. There was recognition proceedings in Canada under the CCAA and the US and under Chapter 15 for the purposes of getting releases of guarantees that Canadian and US companies, not scheme companies, had provided, and that was covered off in the scheme of arrangement. So it was the first UK scheme of arrangement that had been approved or recognized as a foreign proceeding under CCAA. Another one coming up just behind Syncreon was All Saints, the contemporary fashion chain, stores around the world, UK based. That too was a company voluntary arrangement under UK law that was recognized under CCAA as a foreign proceeding. Syncreon was a foreign non-main proceeding, and All Saints was a foreign main proceeding. So let's turn then to those definitions. In outlining the Canadian matrix for recognition, I'm not intending to do a comparison of the Chapter 11 and Chapter 15 and CCAA, but there are a couple of distinct differences, and I know that Judge Gropper is going to reflect on these as well. The CCAA defines a foreign proceeding as a main proceeding if it is taking place in the jurisdiction that is the debtor's center of main interest. So we all know that COMI is what dictates whether we have a foreign main proceeding or a foreign non-main proceeding, and the court hearing the application has to determine that. There is in our statute a presumption that where the registered head office is where the COMI is. But our courts have also developed three principal factors in determining COMI. So considered as a whole, whether the location in which the proceeding has been filed is the debtor's COMI boils down to the three tests. And this was set out in Chief Justice Morowitz of the Ontario Superior Court's decision in Light Squared. Whether the location is readily ascertainable by creditors, the location is one in which the debtor's principal assets or operations are found, and the location is where the management of the debtor takes place. So the review of COMI, which is really not provided by the statute, it's provided in case law, and the case law in Canada has developed along the test that the court is determining that where the location of the proceeding corresponds to the debtor's true seat or principal place of business, consistent with the expectation of those creditors who dealt with the enterprise prior to commencement of the proceedings. So court in Canada recognizes a foreign proceeding. It then has to decide if it's a foreign main proceeding based on the COMI test. And if it's not a foreign main proceeding, if it is a foreign proceeding and it's not a foreign main proceeding, then it is by definition a foreign non-main proceeding. Under the CCAA, any foreign proceeding that is not a foreign main proceeding is a foreign non-main proceeding. And there's no requirement under the CCAA that the debtor applying for recognition of the foreign non-main proceeding have an establishment in that foreign jurisdiction. And that is different to the adoption of the UNCITRAL model law in other jurisdictions, such as the US. And what that suggests is that Canadian courts may recognize more foreign non-main proceedings than other jurisdictions. Then under the adoption of the model law, once the court decides if it's a main or a non-main proceeding, if it is main, then the court shall make an order staying all actions against the debtor company. And if the recognized foreign proceeding is a foreign non-main proceeding, then the court has discretion under Section 49 of our CCAA to grant a discretionary stay in addition to any other relief it considers appropriate. So in order for a Canadian court to take jurisdiction in respect of a debtor company, and recognize either a foreign main or a foreign non-main proceeding, it must be a debtor company having assets or doing business in Canada. Case law has developed on this requirement. Courts in Canada require very little to meet this threshold. In fact, a solicitor's trust account with some funds has been considered assets in the jurisdiction, and not much is needed to satisfy the sufficient connection test. I'll just run through briefly some of the highlights of the model in Canada. Who can apply for recognition? A foreign representative applies, and there is a definition for the foreign representative. And then once a foreign proceeding has been recognized, then Part 4 of the CCAA confers on the court wide discretion to grant any relief that the court considers appropriate with respect to a foreign main or a foreign non-main proceeding, eliciting the principles of comity and cooperation on cross-border insolvencies. The only statutory limitation to that principle of comity and coordination is the limitation contained in Section 61 of the CCAA, which enables a court to refuse to do anything that would be contrary to public policy. And under Chapter 15 of the U.S. Bankruptcy Code, it is the test is manifestly contrary to public policy of the United States. CCAA doesn't have that word manifestly. Whether that means anything or not will depend if it ever comes up in proceedings. But that word manifestly is not in the Canadian statute. We have adopted in our case law the UNCITRAL legislative guide that public policy exceptions should be interpreted restrictively, and that that has been endorsed in our case law, the legislative guide, such that variations from domestic standards are permissible, so long as they are within the realm of what parties might consider reasonable or within our scope of what we view as fair process. I know we're under a lot to cover in this session, so I just wanted to momentarily describe the key jurisdictions that we deal with in Canada. So our experience is predominantly in Canadian courts with the recognition of Canada-US cross-border proceedings. We have a similarity of process. We have a similarity of common law. We share a very long border, which is now open for cross-border travel. The US and Canada are major trading partners, and so there are many companies that have Canadian and US operations. And so that has, through the history of the development of our cross-border law and our application of the UNCITRAL model law under CCAA, most of our experience has been Canadian and US cases. Although, as I mentioned at the outset, we have some new experience now recognizing company voluntary arrangements and UK schemes of arrangements under our statute. One other particular aspect of Canadian process that I would mention is that we have developed in our model court orders. We have model court orders developed by the Commercial List Users Committee of the Ontario Court, and shared with the other provinces in Canada, a model order for recognition of main and non-main proceedings. And in that, we have developed the appointment of an information officer. So there is a foreign representative, as defined, that needs to have the attributes to bring the application. But once a Canadian court recognizes a foreign proceeding, then the appointment of an information officer is intended to be a third party, independent, that is like a conduit of information. It is a link between the cross-border proceedings. It's usually a financial advisory firm that serves as trustees and is licensed to serve as trustees in bankruptcy. And there is a model order that we have developed in the Commercial List Users Committee here in Ontario that sets out what that information officer should do. And it is there and intended to be, that role is intended to be conduit and to assist in the important information, not all information, but the important information that needs to be shared between the two proceedings and between the two courts, and to provide access to information by the creditors and efficiency and cooperation in the ultimate objective, which of course is a successful restructuring in the lead jurisdiction that is then recognized in the jurisdiction that has recognized the forum proceeding. So I see that I've taken maybe a little bit more time on the overview to set the stage, but that is how Canada has, how the UNCITRAL model law has rolled out in Canada under the CCAA and before our courts.
Pamela, thank you very much indeed. I'm going to hand straight over then to Andre in South Africa.
Thank you, Mr. Justice Zacaroli. So I speak from a South African perspective, but I guess what I have to say may apply to quite a number of jurisdictions where we don't have any statutory dispensation in place to deal with this. And in fact, we also had two cases up to now. Well, we had one case and one upcoming case to deal with this exact issue. So what is the situation? In the absence of a statutory system for the recognition and enforcement across borders of a foreign, for instance, scheme of arrangement or compromise sanctioned by a foreign court, its recognition may be problematic, if possible at all. But a court will at least have to be approached. As we know, the aim is usually to try and settle and rearrange claims with the view of rescuing the enterprise or company. But as noble as aim as this may be, there may be procedural as well as substantive issues that may prevent such an option. It must be noted, however, that there may be some solutions in the local laws of a particular jurisdiction that could perhaps be employed, but this may depend on the nature of the entity. For instance, is it a subsidiary company, or for instance, a mere branch of a foreign company, referred to as an external company in my jurisdiction, with an established place of business in a particular other jurisdiction. It is submitted that in each such case, one will have to consider principles of conflict of law and applicable precedent, if any, relating to the recognition and enforcement of foreign court orders as a point of departure. In jurisdictions with some English law roots, the common law as developed by precedent in that jurisdiction should be considered. My own jurisdiction or country, South Africa, has a mixed legal system, basically based on civil law, but with some English law influences, especially in procedural and commercial law, and this is also important in this discussion. So if you look at a particular case, if a South African court, for instance, is approached to recognize and to enforce a foreign scheme of arrangement, for instance, there is, of course, a procedural side and a substantive side. But to note, both the recognition and enforcement of foreign judgments and orders, as well as the recognition of foreign insolvent estate representatives within the realm of especially liquidation procedures, are known concepts in my jurisdiction and in a number of our neighboring jurisdictions as well. These have developed through precedent based on considerations such as comity, convenience, and equity. In general, one has to consider the following aspects when approaching a court for recognition in this jurisdiction. The type of the foreign court order. Is it, for instance, a judgment sounding in money? Is the order a final one? In other words, not a provisional order. The international competence or jurisdiction of the foreign court to have heard the matter in the first place. Public policy. Conflict of law principles relating to the particular type of claim that might be, or claims that might be relevant. And also very important, I think, in the case of a foreign discharge in particular, the applicability of the English-based rule named the Gibbs rule. So these are all considerations that we have to look at when or should we approach a court in this particular region. It may be of interest to say that we had a fairly recent judgment based on an Italian scheme of arrangement, the Cooperativa Muratori and Cementisti versus the South African Companies and Intellectual Property Commission. In this particular case, we had an Italian incorporated company with its COMI in Italy, but it had a registered external branch of its company in South Africa, and it conducted business here over quite some time. So the company in Italy ended up in a scheme of arrangement in terms of the Italian bankruptcy code and they attempted to extend it also to South Africa. What it did, it first tried to do this via the South African business rescue procedure, but our Supreme Court of Appeal finally ruled that the local business rescue procedure was not available to external companies, not subsidiaries, to external companies. In the alternative, the Italian company tried to get the Italian scheme of arrangement recognized here. As to the recognition of the foreign scheme of arrangement, our Supreme Court of Appeal merely made some remarks, since unfortunately there were serious technical procedural issues with this request. But it seems this court was not too keen to entertain this notion. Currently, we also have another case pending, the so-called Steinhoff matter, where the Dutch court sanctioned a special Dutch type of scheme of arrangement in favor of a Dutch incorporated company. And the question will now be to what extent it might ultimately become binding on its South African, once again, external branch, registered in South Africa as an external branch. Suffice to say for now, a number of legal issues like its eligibility to be liquidated in South Africa are now first being considered. So we first have to deal with that before we will get to the real question, and that is, what will the status be of the Dutch scheme of arrangement in South Africa? So in the absence of a statutory dispensation, the question is if and how far a court will go to further develop the common law in this regard. In South Africa, the external company notion is excluded from utilizing local business rescue and, I think, the local statutory compromises. So it basically has no choice but to approach its own jurisdiction. And if it succeeds in the home jurisdiction, the question will ultimately be what South African courts will do with it. However, just to note, the South African incorporated subsidiary part of a group may in principle use the South African business rescue and compromise procedures, which may offer some relief at this point in time, but it depends on the type and the nature of the company. Also to note, the South African Constitution also allows for the development of the common law by the courts. And coincidentally, South Africa has adopted the UNCITRAL model law, but it is not enforced yet because we have decided to include a reciprocity clause linked with the designation, and no countries have been designated since 2003. So we can't use it. Otherwise, at least we could have used with the notion of the foreign proceeding on the procedural side of things. So to summarize, in the absence of a statutory dispensation and clear developed rules, this will be no easy task. In a global group scenario, it may be very frustrating, especially where some jurisdictions involved in such a matter have, for instance, adopted at least the UNCITRAL model law, whilst others have no statutory dispensation at all. So this might cause some serious problems, I think, in a very large group restructuring going forward. As mentioned, apart from procedural issues, there may also be substantive legal issues with such recognition. I think this overview is indicative why we need clear and predictable cross-border rules across the globe. Finally, to quote from a South African Constitutional Court case, Phoebus versus the state, the court remarked, "Judges are the custodians of the common law and the architects of its development. They are protectors and expounders of the common law, and all share an inherent jurisdiction to refashion and develop the common law in order to reflect the changing social, moral, and economic makeup of society." The question from my jurisdiction is, how far will our courts go in this regard? I thank you, sir.
Professor Borraine, thank you very much. Some very provocative thoughts there to mull on. I'm going to use just a few minutes at this stage to really illustrate the restrictive way in which the UNCITRAL model law has been applied in the UK, at least so far as restructurings are concerned. And this is for four linked reasons, I think all premised upon the view taken in England that the model law is about recognition and assistance for procedural purposes only. So the first reason why it's restrictive is because the model law, as I say, is procedural in scope. And because of that, the ability to apply for a permanent staying actions against the debtor in support of a foreign reconstruction is not allowed, because that would be in substance a recognition of the substantive release or compromise of the debt effected under the foreign restructuring. So that's the first limitation. It's recognized that orders might be made in the UK under the model law which have permanent substantive effect. For example, assets might be remitted abroad to be dealt with by the foreign office holder, and that would, of course, have the permanent effect of precluding enforcement against those assets in this jurisdiction and then being dealt with permanently under the foreign system. But a distinction has been made between making procedural orders that have substantive consequences like that and making orders which substantively alter rights. The second limitation, and linked, is that the scope of any stay has been held to be temporarily linked, or temporarily linked, I should say, to the duration of the foreign proceedings. So actions would be stayed in the UK to enable the foreign process to be carried out. But once that process is concluded in a sanctioned plan or scheme, the stay would have to cease. Again, that precludes giving permanent effect to the release or compromise of debt under that foreign scheme. The third reason is that Article 21 of the model law has been interpreted in case law here as not permitting the application of substantive foreign law. And fourth and finally, in the well-known Supreme Court decision of Rubin, one of the matters determined there was that the model law does not go so far as permitting enforcement and recognition of foreign judgments. We have only the existing rules of private international law for that purpose, and rather like South Africa, there are limitations there. Now, I know this is not the way other jurisdictions have interpreted the model law, something I know Allan will be keen to pick up on. So without further ado, let me pass over back to the room to Judge Gropper.
Well, thank you, Justice Zacaroli. You've asked me to provide the U.S. perspective on the enforcement of foreign insolvencies. I'm much better situated to provide the Gropper perspective, which, as many of you know, is a highly opinionated perspective, but perhaps it will be of interest because I am a U.S. lawyer and a former U.S. judge. Andre has described the difficulty of recognition under the common law, and it is fraught with uncertainty. It is fraught with the, in my opinionated point of view, it's fraught with building angels upon pinheads. And so I must say we are, I think, far better situated if we have the model law to begin with, even if the model law has been eviscerated as it has been in the United Kingdom, and I'll come back to that. I would like to say one positive thing about the Canadian version of the model law, because if I may say so, I think Canada has made a real improvement by deleting the requirement that a non-main proceeding come from a place where the debtor has an establishment, which is defined as a place of operations with a human means and efforts. It's not a direct quote. I think it's a real step forward because we, I think, in the model law as adopted in other jurisdictions, took the EU version of non-main recognition, which requires that there be an establishment. And in the EU, it was designed to prevent the opening of unnecessary, arguably unnecessary proceedings. Multiple proceedings in jurisdictions where the debtor only had property, did not have a place of operations. In our world, not in a unitary legal system such as the EU, you can't prevent proceedings from being brought in other jurisdictions, jurisdictions in which we in the United States have had a great deal of difficulty in determining whether it's the Comey or not. And in part, that's the result of the fact that there's no establishment requirement for a Comey recognition. So I think we would be much better off if we had the ability to recognize non-main proceedings from jurisdictions which are in reality the non-main jurisdiction, but still a jurisdiction where the entity is incorporated or registered, and a real jurisdiction from the perspective of being proceedings. We would have to have something else. We would have to have a requirement such as the English have, and I think it's an excellent basis for jurisdiction, if I may say that, a requirement that the jurisdiction have a substantial connection with the company, and we would have to have a further requirement that a plan could be effectuated in jurisdictions which were important to the success of the reorganization. I think the English call that substantial effect. So I think a non-main proceeding would have to have that type of a basis, and I think Canada does through the English concept. But I think Canada has really taken us further. Before I turn to some of the aspects of the English recognition of cases under the model law, I would like to throw out the concept that I think we badly need, and perhaps the III can someday provide that, a really thorough compendium of the laws of various nations and whether they will recognize foreign insolvencies. I think Andre has described the complexities of recognition in South Africa. Many other nations have equal complexities. My good friend Reinhard Daman in Paris has told me for years, well, France will recognize foreign insolvencies through the age-old doctrine of exequatur. I haven't believed him, but he did provide me just today with a couple of cases in which this has actually happened. The French are not notorious for cooperating in this area. The Dutch, will they recognize foreign insolvencies even though they wish to become the center of insolvency in Europe? I don't believe it will be easy, but it would be good to have a compendium that really described that. What do we have? Well, Look Chan Ho, who we heard this morning, has a volume in which he has put together descriptions of the insolvency laws of perhaps 15 jurisdictions. That's a good start. The organization, Law and Business Research, which publishes the GRR reports from London, which many of you may be familiar with, has just come out with a compendium describing cases where different countries have recognized foreign proceedings. And I think that will be a recent tool. The Secretariat at UNCITRAL has a volume called Clout, C-L-O-U-T, that describes article by article cases under the model law, but that is restricted to the model law and not to other statutes or common law principles that will recognize foreign insolvencies. I've attached to our materials the most recent Clout volume from the UN. It's very useful. It's not nearly as well known as it should be, but it is, I suggest, quite useful. Germany, I'm told, has a new statute. Where does that stand? I confess I don't know. and there are others. The Cayman Islands actually has a statute modeled on the old US Section 304. And it would be good to have better knowledge as to where that stands. So now I would like to turn for just a few moments to being quite unfair and contumacious with regard to the English construction of the model law, or perhaps to describe my regret. As Justice Zacaroli just said, the English view the model law as procedural. Well, I don't know exactly where that comes from. There are 32 articles in the model law that took years to develop. It was based on, in many ways, the EU reg, which is hardly procedural. It's hard law within the EU. If the model law can only provide a temporary stay of proceedings and nothing more, what did we do all that work for? Now, I realize the English are saddled with the Gibbs rule, which says that you can't discharge foreign debt that is governed by English law, except by a proceeding in England. But even so, could the model law live with that restriction? Perhaps, but as Justice Zacaroli said, there is case law in England that says that you can't grant any relief under the English version of the model law that goes beyond relief available in England. May I ask, where exactly does that concept come from? Or perhaps I should state that in the US, the result has been exactly the reverse. We will enforce foreign insolvency law so long as it doesn't constitute a violation of US public policy, which I think we all agree is and should be construed very narrowly. As a result, we have, for example, enforced Brazilian cases that provide for substantive consolidation beyond what would be provided for in the US. And Judge Glenn, who is here, has several notable cases enforcing third-party releases. That is a very sensitive area in the US because in the UK, third-party releases are routinely provided in schemes of arrangements or now plans, not so much in the US. It's a very controversial area that perhaps I can come back to later, but I'd like to turn the podium back to Justice Zacaroli, perhaps to discuss any of the areas I have discussed, or in particular, perhaps third-party releases.
Thank you, Judge Gropper. For two reasons: one, time, and secondly, being a lowly judge of first instance, correcting the points that I made earlier that Allan has so articulately criticized is way above my pay grade. I won't be offering a UK response to the, as he put it, contumacious criticism of the UK position. But what I do want to talk about, as Allan just said, is a particular case that I was involved in earlier this year, which highlights a particularly interesting aspect of restructuring and one that's of importance when one's considering the ability to recognize schemes abroad. And that is the impact of a scheme on third-party debtors and the ability to discharge debt owed by third-party debtors. To get to that point, I need to give you some background, tell the story a bit of this case. The case was called Gategroup and involved a global group of companies providing meals to most of the world's airlines, a business massively but temporarily, it was hoped, hit by the pandemic. There was good reason to believe that the business would be as strong as before when the world started flying again. In addition to various bilateral financing arrangements, the group had two principal sources of debt. The first was a senior debt facility entered into by a Luxembourg holding company. That debt was governed by English law, and there was an exclusive jurisdiction clause in favor of England. The second was a bond issue. That was issued by another Luxembourg company, but this was governed by Swiss law with an exclusive jurisdiction clause in favor of Switzerland. Shareholders were willing to invest the funds to tide the group over. So in essence, all creditors were being asked only to extend maturity dates. Much of this was done by bilateral agreements, and 100% of the senior lenders were in favor. The problem was the Swiss bonds. They were held mostly by unknown retail investors. And in order to modify the terms of the bonds, you needed a quorum of 2/3 of all bondholders. That was something in practice which simply was unattainable. Worse, there was at least one institutional bondholder who held a relatively large stake in the context, which was likely to be a blocking stake. The evidence was that there wasn't a suitable restructuring procedure to get around this problem, either in Switzerland or Luxembourg. So the problems were, first, how to confer jurisdiction on another state in which a restructuring process was available, such as England, where the lack of quorum would not be a problem. But secondly, even if you could do that, the standalone scheme for bondholders wouldn't work, at least as anticipated, given the opposition from the institutional bondholder. The solution had to deal with both of those. As it turned out, the bondholder opposition fell away, but so late in the day, the structure was settled on before that was known. The proposed answer was to bring both the bondholders and the senior debt holders within the same single restructuring, notwithstanding that that involved two independent separate debtors. It was hoped by this they could be treated as one class of creditors, with the consequence that the positive vote of the senior debt would swamp any potential objection from the bondholders. That in the result wasn't allowed, but didn't matter. Or if there were two classes, then the idea was to use the cross-class cramdown provision, which came into force in England in July 2020 under the new Part 26A restructuring plan process. That would have overcome the bondholder opposition. Interestingly, Comey of the two debtor companies was moved to England, but the arguments didn't rest in any way upon that. Instead, the solution was to incorporate a new company in England. That English newco then entered into deeds voluntarily indemnifying the senior debt and bondholders. Although it would satisfy that new obligation by requiring the original debtor companies, each of them, to pay, nevertheless, it assumed, although voluntarily, a real obligation. Newco then proposed a restructuring plan, the effect of which would be to amend and extend its own newly acquired debt obligations, but also, critically, to amend and extend the obligations of the original debtor companies as well to the same creditors, relying on case law in England approving the release of third-party debts via a scheme. Now, the first question was whether that fell within the scope of the English law scheme jurisdiction at all, given that a scheme must constitute an arrangement between a company and its creditors. There's Court of Appeal authority that the arrangement with creditors must be in their capacity as creditors. So, for example, it's not possible to effect a scheme, but via a scheme of purely proprietary rights held by creditors. It's long been recognized, though, that rights of creditors against guarantors of the scheme company's debts can be compromised via a scheme between the debtor and its creditors. The justification put forward is that without such compromise, the compromise as between the debtor and its creditors would be ineffective because the creditors would simply pursue the guarantor who would claim over against the company. The question was whether these third-party releases only worked where they were truly ancillary to and necessary for the compromise of the company's own debt, as opposed to being constructed in this artificial way to enable the English court to assume jurisdiction. Showing the influence of 3i in this area, the arguments were presented by Felicity Tobe, Queen's Counsel, and Dr. Riz Mokal of both of 3i, and drawing on a prior decision of the forthcoming recipient of the 3i Outstanding Service Award, one Lord Justice David Richards, I was able to conclude that there was not an absolute bar on using a scheme in this way, but that the degree of connection between the compromise of the company's own debt and that of the third parties owed to the same creditors was a highly relevant factor in determining whether such a scheme would be sanctioned as a matter of discretion. So that meant that the key question became one of discretion only. And here there are two factors of particular importance, I think. The first is, as just noted, the degree of connection, coupled with the extent to which the device is seen as artificial, designed just to assume jurisdiction, and the risk of prejudice to any creditor. Second, the effectiveness of the device abroad, where there is any material foreign element, as there was in that case. On the first point, this was a wholly exceptional scheme. Without the bonds being successfully restructured, the entire global restructuring could not proceed. If it couldn't proceed, then it was clear that the ensuing global insolvencies would destroy value in the group for all stakeholders. The effect of the scheme was only to push out maturity dates. The company would continue to service interest payments throughout the extended period that debt was outstanding. So objectively, it was very difficult, if not impossible, to see how a bonder would have a legitimate objection. The problem was really the purely practical one of getting enough of them engaged to pass the voting requirement of any restructuring. So while the device was conceded to be created wholly artificially, there were very strong reasons as a matter of discretion to permit it to be done in that way and follow the legal construct. As to the second point, and this is where the views from other jurisdictions would be of interest, there was in fact evidence that the compromise effected by the scheme, including the release of third-party debt, would be recognized in the two jurisdictions where it practically mattered. That was Switzerland and Luxembourg. Although, as ever, it's important to note there was no opposing evidence produced, so the views of the expert witnesses were never challenged. I think that in asking the question whether the third-party release would be recognized abroad, it's important to understand the legal basis of that release under English law. As I've noted, a scheme of arrangement must be between the debtor company, that is the subject of the court's jurisdiction, and its creditors in their capacity as creditors. It's only binding, as a matter of English law, between the company and its creditors. The scheme does not, in of itself, effect a compromise of debts owed by a third company to the creditors. Usually that third company will agree to be bound by the scheme, but that in itself doesn't amend the terms of the obligations owed by it to the scheme company's creditors. But at a domestic level, if a creditor bound by the scheme that contains a third-party release sought to pursue the third-party co-debtor, it would be restrained by injunction for doing so, because of its agreement reached with the company, which has been sanctioned by the court, or the agreement that's deemed to have been made through the statutory process. Sometimes a scheme will just short-circuit that by appointing an agent to act on behalf of the creditors so as to effect actual amendments to their rights against third parties. So that's the critical question for any foreign jurisdiction where the scheme needs to be effective. Will that foreign court be prepared to recognize the obligation imposed on a scheme creditor as between it and the scheme company to release or vary its rights as against the third-party debtor company if there are assets of that third-party debtor company in that foreign jurisdiction? That's the $64 million question. And with that, I'll just pass the baton back to our other speakers. But first of all, to ask if either Pamela or Andre wish to say anything on that before you hand back to Judge Gropper, who's going to tell us something about what's coming down the road, hopefully, in terms of new workings. Pamela first, anything to add?
So under Canadian case law and in recognition proceedings, third-party releases are, I wouldn't go so far as to say routine, but there is established case law providing for them. And what you've mentioned is that where they are ancillary or necessary, or whether there's a contribution being provided by the third party or a concession being provided by the third party that warrants a release, Canadian courts, in order to make restructurings work, have been willing to approve those third-party releases. In restructuring proceedings in Canada, in a recognition proceeding where a scheme of arrangement has proposed third-party releases, I mentioned at the outset of my remarks that in Syncrian, which was the scheme of arrangement in the UK, did provide for release of guarantees. Under UK law, that's not an issue, that's routine to be able to provide non-scheme parties that are guarantors with a release in order to make everything effective. That bridge has been crossed. And that was not an issue in recognition of the UK scheme in Canada. The question is whether a more artificial process, as you've described in Gateway, if it is approved by a UK court, then coming to another jurisdiction like Canada, where we have approved or recognized the foreign proceeding, then I think we're into the exception of public policy. So if Canada has recognized as a foreign proceeding the companies that are the subject of the scheme, and the plan has proposed for these releases. They have been duly considered by the UK court and approved. Whether or not a Canadian court would do the same thing on the same facts is not so much the test. The question is whether or not what has been done, it would be contrary to public policy such that a Canadian court would view it unable to recognize it. And so Canada, having adopted UNCITRAL, adopted it not just as a procedural matter, but as an effective way of companies, international companies restructuring. I would view Canada as a receptive jurisdiction for approval of those of that type of arrangement, if it has been approved in the foreign proceeding.
Thank you, Pamela. Anything, Andre, to add? You're still on mute, Andre. Andre, I think I didn't hear me. You're still on mute, Andre. You're muted.
Apologies. Just to say, I think once again, like with the cross-border recognition of a scheme of arrangement or compromise, we will have the same difficulty with third-party liability, or what we refer to as leftover liability in this particular context. The only thing I can offer from my jurisdiction is really within the context of our domestic business rescue procedure, where there's a fairly new judgment of the Supreme Court of Appeal that basically said that in principle third parties remain liable within that context. So if that's anything to go on, I think the same will apply should we ever evolve in that context, that we do recognize foreign schemes of arrangements, etc. So I think it's quite complicated. The only thing that you can work with currently, of course, is if you can pull off a kind of a contractual arrangement between the relevant parties. But currently, a statutory cramdown kind of situation seems to be unavailable at present. Thank you.
Thank you, Andre. So with that, I'll ask the same question of Allan. I think then, Allan, if you can take us to the close with your comments on what's coming down the road in terms of working.
Well, as I mentioned earlier, a number of cases consider whether the U.S. can recognize a foreign third-party release, even though it might not recognize such a release under U.S. law. And the answer has been uniformly yes. I mentioned several opinions of Judge Glenn, but there's also an opinion of the Circuit Court in the Vitro case. So it's been an important issue. I don't know that any case has gone as far as Gategroup in terms of third-party releases. It's been recognized in the US, but that's a particularly imaginative and important application of what I would call the same doctrine. The only caveat I would throw out to the audience is that we now have the, quote, Non-Debtor Release Prohibition Act of 2021, introduced by Senator Warren and several other senators, in effect to undo what was recently done in the Purdue Pharmaceutical case in terms of broad third-party releases in a mass tort situation or context. And I don't know where this law is going to go, but if it is adopted, would that change the picture with regard to recognition of third-party releases? I'm not sure. Does it take third-party releases to the level of being a violation of public policy? I would hope not, but this would be an important statute to take into consideration if, in fact, it's adopted. Thank you.
Thank you, Allan. Do you want to then take us to the last part of the session then, where you're discussing, I think, what
well,
proposals
I
for
did
reform.
want to draw the attention of the group to the fact that in addition to the model law, Working Group 5 has now adopted, and the UNCITRAL Commission has approved, 2 new, not so new perhaps, model laws. One on the recognition of insolvency-related judgments, which would, in effect, reverse the Rubin decision in the UK. In the US, we will recognize foreign insolvency judgments, both in the nature of foreign discharges, but also we will permit the recognition of, under the model law, of other foreign insolvency-related judgments. So I don't think we need it, although we can certainly consider it, but no nation has adopted it yet. Similarly, the UN Commission approved Working Group's 5 formulation of a model law on group insolvencies, which tries to impose or create some order in multiple insolvencies affecting members of a corporate group. The model law itself really doesn't deal with this area, creates the nature of a planning proceeding and a group representative to try to bring diverse insolvency proceedings to a constructive end that actually effectuates a resolution that is better for everyone than separate competing insolvencies would be. In your materials is a new document, not yet published by the Secretariat, but in the process of being translated into the 6 languages of the UN. It is what Professor Janger has termed a threefer. It is a single version of the 3 model laws put together. I'm not sure that if we adopted it in the US, we would put it together in exactly this fashion, but it attempts to show how the new model laws can be effectuated as an amendment to the current model law, which I think is the easiest way to proceed, although Working Group 5 did not proceed in that fashion. It's in your materials together with a memorandum from the Secretariat that describes how it is set up, what its intent is, and I would commend it to all of you and commend to you the issue of adoption of these laws into domestic legislation, because I think it would strengthen our current system greatly. Thank you, Justice Zacaroli, for allowing me to provide a brief advertisement for this subject.
Thank you, Judge Gropper. And I think with that, we are exactly to time. But I just add this, that I'm not close to the detail. I do know serious work is being undertaken in the UK to consider to what extent the new model law on insolvency judgments will be enforced or enacted, and to what extent, if it is, it would solve or correct or reverse the Gibbs issue, which you touched on earlier. So with that, I think I'll hand back to the room.
Thank you so much for that excellent panel. We're out of time for questions, but we really appreciated all the vigorous discussion and fleshing out the differences between the different jurisdictions and how we deal with these complicated issues. So with that, we are done with the panel, and thank you, everyone. And we'll turn in the room to lunch, which will be held downstairs. And then for people remotely, we are regrouping at 2 o'clock.